Thank you, sir. Now it's a pleasure to invite Justice Rajinder Sacharji, former Chief Justice, Delhi High Court, founder of the People's Union for Civil Liberties, former UN Special Rapporteur on Right to Housing, and a person who has been involved actively in the civil liberties movement in India, Justice Sacharji.
Otherwise, Dr. Bakshi, but open that to me. Mr. Pandey, Professor Thaglal, and the present people. I was first curious to know, my name carries HMJ. I haven't understood. J possibly I think is a mistake for judge, but HM I have not been able to understand. If it is meant honorable something, I think it's quite superfluous. I am really pleased because frankly I always get very nervous when I go to the academic classes. It's all right to sit in a chair and shout that you know all the law, but when you really come with the raw things, you really realize what work has undergone it to make what it is. The subjects that you've chosen are too many. I've just picked up one or two subjects on which I wish also to have a knowledge for the person, and which is more important these days is death penalty. This has, to people like me who don't believe in death penalty for long, it's certainly a great relief that a university, and such distinguished university here, is taking up the subject, one of the subjects. And the institute, I take it also, will come out with facts and figures to show that it really hasn't helped in any way the institutions of criminality in stopping by murders. Because this again going to get into a debate in the parliament because of what recently happened in Delhi. Incidentally, I find that the death penalty was briefly banned in China between 747 and 759. Modern opposition to death penalty therefore stems from the book of Italian Beccaria de Lette on Crimes and Punishment, published in 1764. In his book, Beccaria aimed at to demonstrate not only the injustice, but even the futility from the point of view of social welfare of torture and death penalty. Influenced by the book, surprisingly, Grand Duke Leopold of Habsburg, who immensely enlightened monarch and future emperor of Austria, abolished the death penalty in the then independent Tuscany, the first permanent abolition in modern times. On 30th of November 1786, after having de facto block capital execution, the last one was 1769, Leopold promulgated the reform of penal code, but abolished the death penalty and ordered the destruction of all the instruments for capital execution in his land. In 2000, Tuscany's regional authorities instituted an annual holiday on 30th of November to commemorate the event. The event is commenced on this day by 300 cities around the world celebrating the Cities of Life Day. In 1849, the Roman Republic became the first country to ban the capital punishment in the Constitution. The last execution in Portugal had taken place in 1846. However, very powerful voices in the 19th century started this, and that's, as they say, the irony of it. Because we swear by Professor John Stuart Mill as a rationalist, as a person who said one man even against the rest. And this is what he had to say. Does finding a criminal show want of respect for property or imprisoning him for personal freedom? Just as unreasonable it is to think that to take the life of a man who has taken the life of another is to show want of regard for human life. We show, on the contrary, our regard for it by adoption of a rule that he who violates that right in another forfeits for himself, and that while no other crime that he can commit deprives him of his right to live, this shall. Surprisingly, the most rationalist of the person in 19th century is advocating a death penalty on the ground for fine for a traffic being similarly the taking of a life. Of course, so far as the great leaders and philosophers have held, Jayaprakash Swain said, it's ultimately a question of respect for life and imprisonment. And above all, Dr. Ambedkar, father of the Constitution, said, having regard to the fact the proper thing for this country is to abolish the death sentence. The High Commissioner for Human Rights is spoken against it. President of Chile, Chile has passed through various stages, some unmentionable things, but nevertheless, Guerrero Fay said, I cannot believe that to defend life and punish a person that kills, the state in should and kill. The death penalty is as human as the crime which motivates it. We've gone on this for so long. Now, sometimes it is said, well, keep death penalty, but after all, the Supreme Court has said it is rarest of rare. The phrase sounds very good, but what in actual practice has happened, would surprise you to know that, ironically, after the rarest of rare doctrine was propounded in 1980, Supreme Court confirmed death penalty in 40% of the cases in the period 80 to 90, whereas it was 37% in 70 to 80. And to our embarrassment, one of the case in which death sentence was confirmed because of this rarest of rare not being abolished was one of our very top judges. So that this rarest of rare doctrine is just a phrase. For the High Court, the figure rose from 59% in 1979-80 to 65% in the post-1980 when it was a rarest of rare doctrine. Now, it obviously springs from the myth that it will lead to increased murders. That's what one says. I mean, frankly, many of my close family members would go at my throat when I said, well, somebody is killed and you don't do it. But in India, we have an example. In 45 to 50, as you know, state of Travancore was an independent state. There was no death penalty. And there we have 962 murders. Then it became a part of India. And obviously, Indian Penal Code and criminal law started applying. And we had 967 murders. Post-application were more than the pre-period when there was no death at all. In Canada, after the abolition of death penalty, the homicide rate has declined. In 2000, there were 542 homicides in Canada, 16 less than 98, and 159 less than 1975. A survey conducted by United Nations in 1988 concluded that research has failed to provide any evidence that executions have a greater deterrent effect than life imprisonment. And in 1997, the Attorney General of Massachusetts, at the central level, the USA Supreme Court has upheld it. But there, the states can legislate on that separately. And Massachusetts said there is not a shred of credible evidence that death penalty lowers the murder rate. In fact, without the death penalty, the murder rate in Massachusetts is about half the national average. New York Times did a survey in 2000 and found that during the 20 years, the homicide rate in states with death penalty has been 48% to 1,000% higher than in the states without death penalty. Death penalty was, as you know, abolished in 1965. They always vote not on party lines. It's a free for all. It's an individual. Any person can vote. And it has been upheld time after number because they go to parliament every time. The South African court, which of course pays quite compliments to our courts also, has unanimously ruled as far back as 1995 that death penalty was unconstitutional as it constitutes cruel, inhuman and degrading treatment. The grievous danger of irreversibility and of course being executed is no panic reaction considering that 500 people have been executed in the United States since the Supreme Court reinstated the death penalty. And since 1973, 123 prisoners have been released in the USA after evidence emerged of their innocence of the crime for which they were sentenced to death. There is a Baldus report in the United States which always says between the white and the black, the danger of a black getting death sentence. And that is true in our country if you talk of the Dalit and OBCs as the others. But more important than this is that even when you are receiving it, look at the way this matter has been dealt with on the executive side. We've had the case, President Patil was very much blamed, I think wrongly, because the president is just a signature thing. The recommendation was sent by the Home Minister, Mr. P. Chidambaram, at that point of time. There were cases of murder, rape, death sentence given, affirmed, and Mr. Chidambaram sent the recommendation for release of the thing on commutation. Now, when these things come into play, obviously, a cynicism, a sense of desperation, a sense of understanding will arise. What is happening? If death penalty is to be done for this, then is it to be left to the choice of the executive, even the recent one, I think, and frankly, what is happening is also of the Supreme Court. Since the Supreme Court has given the judgment, I take it can't be a contempt. But it's a horrible judgment. I mean, those who believe in death sentence, for me, people like me who don't believe in death sentence, even the foolish and the vague judgments which don't give a death sentence, I am quite content. But in a recent judgment, a person rapes his daughter, kills her, gets a death sentence, comes out on parole, kills his second daughter and wife, death sentence given, affirmed to the High Court. The Supreme Court says it is rarest of rare case. Why? Because the poor fellow has no family. When he came out after the death and rape of his first on parole, his wife refused to let him come home, and his second daughter wasn't talking to him. So this is a redeeming feature. Can one imagine the enormity of it? And that happens because you don't like to. I mean, frankly, as I said, even the most enormity of contradiction in the judgment, I don't react badly because I don't believe in that sentence. Then why not be honest about it? And that is what really happened. As you know, President Kalam refused to do it, and they found a very simple device. He sent back the cases to the Home Ministry saying, will you let me know what is the economic background, what is the offense, what have you done? And the period lapsed. President Narayanan was even more radical about this. Knowing the working of the government, he sent a case back to the government for our secretariat, and during this time it never came back. Therefore, I feel there is a time when not only the institute but the university should very seriously consider and come out with facts and figures. Let there be a public debate about it. There is no emotion about it. As a matter of fact, some people feel that there is an emotion about it. There is no emotion about it. There is a rationality about it. The whole discussion has to be based on reason. There should be, after 160 countries in the world have abolished the penalty or a moratorium on it. Therefore, that's one of the things which I don't know whether technically it would come before the institute, but certainly it would come before the people in the universities at various points of the world as how to do so, because you will otherwise run. And it is going to come in front because they are going to now amendment made in the most of the criminal laws following that unfortunate death in Delhi. And therefore it's time when people really come out with it and make the thing do. There are so many subjects dealt with the thing that it would be impossible for me to deal with it. But I like to mention about this legal aid thing, the PIL as it is. We passed through various stages. As when earlier, when Upender and others went through, as you know, the whole Dowry law was changed because he and Professor chose to go in the Mitra case. I'm not against PIL, frankly. I myself, when I was there, happened to do it. But the mistake that has been made, and then I go to the new universities, I always figure I wish I was young and study in this atmosphere. The close, the colossal intellectuals which now teach us, because with all respect to my teachers, extra reading was taboo even for the teachers in our time. They could only tell us, well, what is a crime, 1, 2, 3 section, etc., but nothing more. I mean, that we could read. It's really wonderful. I mean, I must pay tribute to the university, and I hope it remains a little apart. Again, like when the Delhi University was formed, I'm quite sure it was probably like this, but then it became like this. I hope this remains further off. If you're at the back of it, you won't let the people come from that side and really enjoy it. Thank you again very much.
Thank you, sir, for your inspiring message. To borrow the words of Professor Upendra Bakshi, let us hope the waywardness of the in the jurisprudence of rarest of the rare case may slowly end, and let us have a clear, coherent policy of what is the rarest of the rare, and let us also stop secret hangings. So now I would request Professor Upendra Bakshi to deliver the inaugural address. Professor Upendra Bakshi is a distinguished professor of the National Law University, Delhi.
Professor Mayor, Professor Ved Kumari, the distinguished, and Professor Manohar, the distinguished awardees of this annual conference, 36th All India Criminology Conference, the chair and the vice chair of the ICS, and distinguished colleagues who have served the society with vigor and freshness, young and old, for so long. My distinguished friend, whose enthusiasm for people's right has not dimmed with the relinquishment of his high office or with the necessary dimming of health that age brings. My dear friend Justice Isindra Sachin, Vice Chancellor Ranbir Singh, Registrar Sri Krishna Dev Rao, Professor Bhuvan Pandey, between whom I stand between him and you all, so I'll try to be short, and distinguished colleagues, students and friends, and distinguished guests. I want to make a few sundry remarks, 3 or 4 introductory remarks, and 3 or 4 hopefully serious ones. First, as to preliminary remarks, it's very difficult to speak after Rasindra Sachin. He speaks from heart, and he speaks from a cool head amidst a lot of turbulence of his soul. It's quite right to remind us about death penalty. And as I noticed, Professor Pandey is going to go further into the discussion of the rarest of the rare, or the routine, most routine of the rare that is now being practiced. I will not expound on that, excepting to say that I've been arguing since 1983 even 82, that judicial despotism is as bad, if not worse, than executive and legislative disposition in matters of life and death of Indian citizens. And therefore, if our Supreme Court can meet in a bench of 13 to consider Golaknath, or in a bench of whatever in 11 and 13 in Keshavananda Bharati, these were property right cases. When it comes to awarding of death sentence, there is no reason on earth why the Supreme Court as a whole should not sit and decide the issue. And they should decide the issue of redress of dread by a unanimity. This spectacle, the pathetic spectacle of two judges' benches, must now end. Because nothing is more unseemly as an adjudicatory performance, and nothing is more constitutionally obscene than the way death penalties are being awarded. I won't go any further on this, because this is not what I want to speak about. And Professor Pandey will speak about it with more learning. I appear before you today, the first remark, as a distinguished professor of law at this university. I don't know whether the Verma Commission has, in its voluminous criminalization, defined seduction as an offense. But if I'm here as a distinguished professor of this university before you, Ranbir Singh is guilty of the new Verma crime. I'll leave it at that. I must also say that I have written some things down, but the words I have in my paper, handwritten notes, are almost as illegible as this so-called Indian criminal justice system. So you might find me faulting here and there, but that is the nature of the enterprise. I also want to say that I'm not a criminologist. And my guru, Professor Hans Kelsen, the founder of the pure theory of law, when I had the rare privilege of visiting him every fortnight for 3 years, when I was a student at the University of California at Berkeley, when I told Professor Kelsen, I said, "Sir, I'm not a philosopher." And he said, "Young Bakshi, that acknowledgement was highly superfluous." So my saying that I'm not a criminologist is of the same order of superfluity. But I have tried to teach criminology. I've benefited from a generation of my students and colleagues who have written with great insight their masters and doctoral and other works with which I had the privilege of association. So I'm grateful to them all. What I liked about criminology, what I realized when I did criminology teaching, was a fundamental truth, that there is no hope in the hell for anyone to understand the idea and ideals of a legal or constitutional order or system without understanding the dilemmatic and agonizing nature of crime and punishment in India. And then one cannot really be a law teacher of worth the name if one has not at least tried to seriously address the concerns that criminological sciences and research foster. It's not good enough to be a specialist in constitutional law, international law, or whatever, intellectual property rights and all that. It's all right. These are important areas. But not to have any grounding in criminology is a disaster. And I hope that this great university does not foster that disaster. In other words, it should try and encourage as much communication between various disciplinary specializations in the faculty and various research areas of the students, between their specialization and this thing called criminology, which of course includes now, I have distinguished friends who talked about penology, and Professor Dr. Rajan and many others who had the pleasure, something called victimology. I know that we all owe a great debt of acknowledgement, a huge one, to Sir Hari Singh Ghosh, who was, I think, the pioneer in this field. He dedicated all his earning and ancestral property to the foundation of Sagar University and founded this particular discipline in India. And there have been generations of great names who have sustained the Gorian vision in a variety of ways. So in a sense, I dedicate my remark to Sir Hari Singh Ghosh today, but also to people like Dr. Shukla, Dr. Panakal, many other friends that we all know. Some of them are here, and some unfortunately are elsewhere in the wider skies. I salute their spirits. What is my credential here? Well, I bring you an outsider perspective to criminology. Outsider from the point of view of sociology of law, from the point of view of human rights, from the point of view of comparative social theory of justice. And since the conference is about rethinking human rights, rethinking criminology, I requested Professor Rao to share with you a paper of mine. This is a proof paper called Rethinking Human Rights, which is coming this year in a publication from Bangalore called Asking We Talk. But please have a look at it. There I address the problematic notion of rethinking itself. So let me now come to some of the few substantive issues and then I'll end. First, my first remark. Before I go there. When I learned criminology, and I used to discuss it with my students in Delhi, and in fact I was a place called South Gujarat University, where I was the Vice Chancellor. I'm a kind of recidivist because I became a great in Delhi. But the first was a juvenile offense and the other was an adult one. Regardless, I'm still suffering from the consequences of beheading two universities. Nevertheless, when I started teaching in Surat, nobody wanted to teach in Surat Law College, VT Choksi Law College, something called criminology. And I wanted to teach. I always taught whichever office I held. And then I saw the program, Sutherland, all the big books in English, which students in Gujarati medium could never read. They had no idea of how to read standard works written in English. And at that time, a valiant woman called Phulan Devi came to my rescue. She had just surrendered to the police. Papers were full of her. And I did a very remarkably successful and satisfactory course on criminology by asking my students to read everything in the newspaper and the media and then go back to the classics of criminology on causes of crime and so on. So sometimes teaching the newspapers, I'm talking about before 24/7 channel. I don't think you can do criminology with Arnav Goswami or Barkha, but perhaps you can try. But you can certainly do it with good, intelligent newspaper and monographs. At that time, a remark that impressed me very greatly, I forget the authors, who said criminology is the queen of social sciences. And it is true, because everything begins in social theory, almost everything, with criminology. Even consider the history of power and deviance. Criminology starts with anthropology, physical anthropology, measurement, chronology and all that. It starts with problems of causality, causes of crime and consequences of punishment. It starts with empiricism, concerned with finding out what really goes on in criminal justice systems. It incorporates interactivity. Most of practice of criminology is what is known as forensic sciences. Therefore, you have to be conversant with latest developments in natural sciences. You begin with physical anthropology and you end with genetics. You cannot do forensic science outside. We know all that. And also, as a policy science, criminology has played a great role. I'm talking about outside India. As far as India is concerned, we can't talk of queens and kings because we abolished monarchy by the constitution and we've even done away with privy purses. So I can't speak of, well, criminology in India is the queen of social sciences. I can only say that in our occasional republic, occasional because we only remember the 26th January that we had a republic, otherwise as Justice Thatcher said, so many thousand people get killed in police firing and counterinsurgency operations without redress, so many Justice Thatcher. As an occasional republic, we can only speak of criminology at this stage of adolescence in India. And I think that is important. I will not go any further on that. Now let me come to my quick remarks. Not more than 8-9 minutes. First, and very simple, I put questions, they are crude, they are not refined, they will not be annotated. I put them as provocations for your kind consideration. First, how may we relate criminology to Indian legal system? Indian legal system is deeply pluralistic and identified a long time ago two big legal systems in operation in India. One which I called state legal system and other which I named as non-state legal system. Most of our criminological studies are addressed to the former, not to the latter. But we know that non-state legal systems exist and they contradict the ideologies of the normative ideologies of the due process and so on of the state legal system. How do we study? How do we reorient criminology and its concerns in India to the conflicting and competing conceptions of legal order today? I think the question certainly should be on your agenda. Secondly, even if we confine ourselves to criminological imagination, to state legal system, there are too many state legal systems themselves. There's a de facto state legal system and there are several de jure state legal systems. And there are many fairy stories and there are many horror stories about Indian state legal system. I'm not going to go there, but I'm going to ask you to consider India as the most developed country in human history. If the measure of development is not GDP or GHP, gross happiness, GHI, gross happiness index or whatever, if the measure of development is what I call GLP, which is gross legislative product, nobody can beat India in recorded human history for production of laws, executive laws, delegated legislation, amendments, codification, law reform. Now, if we are living in a society, in a legal civilization which venerates GLP, how do we at all think of reforming the state law? Well, one hint obviously is, well, we know that every time you create an offense, it creates an enormous overload on the criminal justice system. Invest from police to the Chief Justice of India, from the poor, lowly paid police constable to Chief Justice of India. Because our Supreme Court is suffering. You know, there's a character in Mahabharata or Ramayana, Rukodar. And Rukodar is a person with enormous appetite. He is a giant. Our Supreme Court justices have developed an enormous hunger for jurisdiction. They are the modern recorders of Indian jurisprudence. And I say without respect. I will not return to these bourgeois manners. Judges have to be subjected to fair but relentless criticism when it is deserved. And I say therefore full responsibility. And imagine, I'm not going into death penalty, people who have waited for 20 years on gallows, being Virap and associates, now on a public interest petition asked by the Supreme Court to be regarded as the rarest of rare, and after 20 years, after 100 years, after 60 years, we got a precedent who will go down in history as a hanging precedent, who already sanctioned death sentence on them. What business have citizens to file SLPs in matters regarding guilt and innocence of Indian citizens? I've always believed, even when we wrote the Mathura open letter, we did not support the review, we did not ask Supreme Court to revise its decision. We said, you learn from our protest. Law reform, making people guilty of offense. Judicial activism is not for creating offenses which are not on the statute book. Judicial activism is not for creating punishments which did not exist before, etc., etc. So, how do we address the problem of GLP, civil society irresponsibility in matters of going beyond its mission? Civil society activism is to confine to participation, to law reform, etc., etc. It cannot be ever a substitution of finding of guilt and punishment through the streets. I've always said it's nothing new for me. So GLP is not the only problem. Judicial arbitrariness is a problem, executive arbitrariness is a problem, and so is civic society arbitrariness in the matters of criminal law and administration. I must end shortly. Yes. Very shortly. I have 2 more points, but I won't take your time. We have criminology of state power. Do we have what I would like to call as subaltern criminology? Do we understand not just the impact of criminal justice system on the rightless and the worst of peoples of India, whom I call disenfranchised, disadvantaged, and dispossessed citizens? Do we understand what they think of crime and justice and punishment? A stunning book 20 years ago written by an American scholar called Punishment is the Crime. And that articulated the view from below of people who felt the punishment itself was a form of state crime against them. Do we have such studies in the studies of Indian criminology? I leave that, and I leave much as besides. Do we understand do we have a theory of state in Indian criminological studies? I've identified 7 constitutions of India in my writings, starting from Chacha Nehru, which lasted from 1964, then to Indira Gandhi Constitution 2 and 3. The first was the bank nationalization, and so when state becomes the finance capitalist. Then comes the second Indira Gandhi Constitution, that of emergency. Then comes the fourth Indian Constitution of judicial populism and activism after the emergency. Then comes the fifth Constitution of Baba, Rajiv Gandhi, which globalizes India, liberalizes India. I'm not making any political statement, I'm just describing, time is short. I don't mean any disrespect. Then comes the 7th constitution of our dear friend Manmohan Singh, hyper-globalization of India. This is a short way of putting this. There have been fundamental changes in political formation and domination in India within 60 years. How do we relate study of causes of crime and impact of crime, regardless, as if it was a never-ending theme in itself, regardless of the changing political formations? Is a question I want to put. Of course, I can't do any more than that. And finally, the question, how do we feminize the art and craft of Indian criminology? How do we feminize our research methods, our research agenda, and our research output, taking violation of women's rights as human rights seriously? Unless Indian criminology does it, it is not likely to ever go to the task of feminizing sovereign power, which is a very difficult thing. But at least we can start from where we are. Well, I must abruptly go away from here. And I must say that if criminologists and penologists and victimologists are not just great experts as they are in their field, but if they were also going to remind themselves that they are citizens of India. And as citizens of India, there is a small little chapter in the Constitution, and Professor Bajpayee's review of Indian criminological developments, I'm especially having it in my mind. I don't think our criminological studies are based on the idea of citizenship-created knowledge. Now, what is the citizenship-based knowledge? That is Article 51A of the Indian Constitution, enacting the fundamental duties of all Indian citizens. And there are 7 or 8 of them. And I wonder whether we are oriented in teaching of criminology, of forensic science. Why should Modi or medical jurisprudence rule us from his grave, several graves? I know several Indian judges have been editing and headnoting and so on. That's perfectly all right. That's the affair of trade, not of learning. Why have our scholars not produced a constitutionally based, oriented text on forensic science and other aspects? So, thank you. Bye.